Hi, welcome to valuationpodcast.com, a podcast and video series about all things related to business and valuation. My name is Melissa Gragg, and I provide online divorce mediation and valuation services based in St. Louis, Missouri. Today, we're going to discuss the marital balance sheet, trusts, and divorce with Bob Boyd and Tish McDonald from Atlanta, Georgia. Bob is a co-founder of Boyd, Collar, Nolen, Tuggle, and Roddenbery, and a leader in family law who has received recognition from his colleagues across Georgia and the nation for his work in high net worth divorce litigation and contested custody cases. Tish McDonald is a partner in the trial and global practice group at King Spalding. She focuses on complex commercial litigation with an emphasis in trust and estate litigation. She also gets involved with litigation for nonprofits, real estate, and government entities. Well, and we talked about, setting up the trust. You talked about, funding the trust. We have beneficiaries and we have fiduciary responsibility. And I think if Tish could talk, because when we're looking at these trusts, some of the issues in a divorce, because most of the time they were created for other reasons. Typically not to just protect somebody from getting divorced from getting stuff, right? But there's usually some language about the divorce of a beneficiary or the divorce of somebody else that could be included in that language. But another term that people don't necessarily understand is the fiduciary responsibility of the trustee in some capacity, or the control of the beneficiary or the spouse that, people are getting divorced, the control they have over the assets. And those two become very important keys to figuring out who has access to the assets, right?
Exactly. In fact, Melissa, you're hitting on a really important point. Sometimes a trust can be set up by one spouse or the other or both with absolutely solid estate planning reasons for doing so. As Bob indicated, to keep upon one of somebody's death, the Internal Revenue Service from attacking those as being part of that individual spouse's estate. Sometimes they're very, very valid. Problems come, though, usually when, and this is what we see typically, it's not so much you're attacking the formation of the trust, a spouse isn't, but they are attacking some sort of contribution that got made. And the allegation is you did this when you were contemplating divorce. You wanted to transfer that asset out of the marital estate into the trust. And the point you were raising, Melissa, I think is a good one, which is the identity of the trustee in that situation is very important, because there is a doctrine known as a fraudulent transfer, fraudulent conveyance, and there's certain what we call badges of fraud a court will look at to find out, just the circumstances look like the transfer was inappropriate. And the reason why the court looks at badges of fraud is because you're going to rarely have a spouse come in and say, you're right, I transferred this, I meant to defeat my spouse's claims. And one of the badges of fraud is the most important one is, who is the trustee that you transferred this to? Is that person an insider? And an insider can be defined as someone that's in your family. It can be a relative. It can be a business partner. But those trustees are absolutely going to be focused on, because of the reason that you said, Melissa, is the beneficiary behind the scenes directing, i.e. the spouse directing that trustee what to do. So the more independent, the better if you're trying to protect trust assets. I do want to mention, because Bob and I've seen this situation before. Usually the trustee is deposed in a certain situation. And sometimes you have one that is I'll just use a common word here, clueless. Mm-hmm. They have not seen the trust instrument. They don't know what they're doing. They can't answer simple questions. But the truth is, if that person really is not an insider, it doesn't matter. It's probably going to be protected, because you remember from law school, those listeners to this podcast, is that a trust doesn't fail for want of a bad trustee. Well, similarly, a trust doesn't fail for want of a bad trustee. But when Bob and I've litigated, we see this get on both sides. We have been very hard on a clueless trustee, but we've also defended trustees that aren't very experienced against such claims. But that's usually a red herring if they're truly independent.